I suppose the one thing that's important is that you folks can hear me all right. Okay.
Okay, all right. Great to see all of you. I have to say, before I give my introductions, for many of us students, including myself, this is my first conference. I've never really been to a real legal conference. And so it's great to see the personal conversations going on, because I always hear that's a highlight of going to one of these. So love hearing it, love hearing it. So to start, our third panel will be focused on the following: whether and how the U.S. government should exercise its compulsory licensing authority under 28 U.S.C. Section 1498 and the Bayh-Dole Act. It will be moderated by Professor Artie. Professor Rye is the Elvin R. Latty Professor of Law at Duke. She is an internationally recognized expert in IP, innovation policy, administrative law, and health law. From 2009 to 2010, Rye headed the Office of Policy and International Affairs at the United States Patent and Trademark Office, where she led policy analysis of the patent reform legislation that ultimately became the American Invents Act. A graduate of Harvard Medical School and Harvard Law School, her academic publications have appeared in Science, the New England Journal of Medicine, JAMA, the Journal of Legal Studies, Nature Biotechnology, and the Journal of Law and the Biosciences. And with that, I am honored to introduce Professor Artie Rye and begin our third panel.
Thanks so much. So as to not embarrass my former colleagues at Harvard Medical School, I did not graduate. I attended Harvard Medical School, but I did not graduate. And I don't know whether they should be tarred with my name or not. I did go to the law school and graduated there. So, all right. Well, thank you so much, Zach, for that very generous introduction. And you've given the title, which is quite a mouthful, but it turns out that compulsory licensing can be exercised in many different ways under the U.S. government's power, or at least two different ways that we're going to talk about. And so Section 1498 applies to all patents, and the Bayh-Dole Act compulsory licensing provisions, such as they are, apply to patents that emerge from government funding. So there have been longstanding concerns about the use of compulsory licensing, and most recently, these concerns have popped up again, perhaps in the context of some proposed regulations put out by the National Institutes for Standards and Technology for public comment. And I believe our guests will be talking, our panelists will be talking about that to some extent. So very topical subject. But more generally, and perhaps a little less topically, the issue of compulsory licensing, or at least the threat thereof, raises important questions regarding whether and how it should be used. So, for example, if the answer to whether is yes, there is the whole question that also came up in the first panel with respect to how to calculate and the institutional framework that should calculate. There's also a set of issues that's slightly independent of patents, but we will discuss as well, which is that since patents often don't disclose everything that's necessary to make and use the product, contrary to the statutory requirement. There is also going to be know-how, trade secret protected know-how, and in the context of biomedical products, data exclusivities that have to be dealt with if the government actually wants to get the product produced. So we have a terrific panel to address these issues, and they have all extensively written and discussed these issues of biomedical innovation and access. And I would say that it's fair to say that they're all public figures to some extent. So if you don't know who they are, that's on you. Their bios are available in the materials, so I will just give name and affiliation. So in order of speaking, first we have Professor Eisenberg, who is the Robert and Barbara Luciano Professor of Law at the University of Michigan. Next, we have Tahir Amin, who is the co-founder and co-executive director of the prominent Access to Medicines group, I-Mak. Third, we have Henry Hadad, who is the Senior Vice President and Deputy General Counsel at Bristol-Myers Squibb. And then finally, we have Professor Sachs, who is at the Washington University School of Law and has written extensively on all of these issues, including the one that we're going to talk about today. So they're going to speak for just a very short intro period, seriatim in that order, and then we will have them all react to one another. I'm sure they'll have many things to say about each other's presentations, and then I will have some questions, and I will also try to keep an eye out for audience questions because I often find those to be very, very useful, and so I will simultaneously keep an eye out for those as we do our discussion. So please post your questions as they emerge in your mind. So with that, Professor Eisenberg, could you take it away?
Yes, thank you so much. I'm so delighted to be included in this very interesting discussion. I am going to focus my remarks on the Bayh-Dole Act, which is something that I know more about. It's a topic I find endlessly fascinating, and I've been thinking about off and on for the past 30 years or so. So I'm going to be focusing on march-in rights under the Bayh-Dole Act. The Bayh-Dole Act is about using patents in the results of government-sponsored research to facilitate technology transfer and further investment in commercial product development. And in 1980, this was a big change for some agencies that had previously thought that the best way to achieve widespread access to research results was to leave everything in the public domain. So although the goal was to promote more widespread access to practical benefits of government-sponsored research, members of Congress worried in 1980 that Bayh-Dole patents could easily have the opposite effect, that they might restrict access to new technologies that had been created with taxpayer funding. So Congress put some safety levers in place in the statute. And one of those safety levers was march-in rights. The statute gives federal agencies that funded the research behind Bayh-Dole patents the right to march in and require patent holders or licensees to grant further licenses to responsible applicants on reasonable terms, or to grant such licenses themselves under certain circumstances that were specified quite clearly in the statute. The specified circumstances include failure of the rights holder or licensee to take effective steps to achieve practical application of the invention, and also necessity to alleviate health or safety needs which the rights holder is not reasonably satisfying. Practical application was further defined in the statute to mean that the invention is being utilized and that its benefits are available to the public on reasonable terms. That's not me talking, that's the language of the statute. The statute authorizes federal agencies to use march-in rights to extend further licenses in order to ensure that the benefits of the invention are available to the public on reasonable terms and as necessary to alleviate health or safety needs. No agency has yet exercised march-in rights, although NIH has considered and rejected a half dozen or so petitions for march-in licenses over the 40 years that the system has been in place. And I think that's partly because current regulations make it difficult and cumbersome. But partly, I think it's also because it's very unpopular with important constituencies of NIH. Nonetheless, the National Institutes of Standards and Technology has a currently pending notice of proposed rulemaking that was published in the Federal Register in the final weeks of the previous administration, proposing to clarify that march-in rights shall not be exercised by an agency exclusively on the basis of business decisions of a contractor regarding the pricing of commercial goods and services arising from the practical application of the invention. This is not a clarification. This is an interpretation that is contrary to the plain language of the statute. Moreover, it uses rulemaking by NIST to take away discretion as to determinations that the statute directs funding agencies to make, and that can only be made on a case-by-case basis. NIST has statutory authority to promulgate procedural regulations, but not to determine when the exercise of march-in rights is appropriate. The statute clearly allocates that judgment to the funding agency. So this proposal is open for public comments until April 5th, which is coming up soon. Put it on your calendars. And meanwhile, I expect we will have a lively conversation about this issue today.
Indeed, I'm sure we will. So very topical. Mr. Amin, could you go and discuss your affirmative statement of the case?
My affirmative statement. So the question is whether and how. Whether, yes. How is a much more difficult question, given the way, if you look at 1498 and the Bayh-Dole provisions are worded. I would particularly look at 1498, and there's been a lot of discussion by people who are far more how do you say, educated on this particular provision. But the two words that come out to me are the words reasonable and entire compensation, in terms of how one is compensated when a government actually enacts 1498. And now, when we look at, particularly in the pharmaceutical sector and drug pricing, and we've seen in the last 4 or 5 years how drug pricing has really been on the agenda in terms of the rising prices. And my organization has done a number of work looking at this sort of patent situation around drug prices. And, you know, if you look at the top 10 selling drugs in the United States, then sort of the average price increase has been at 71% between 2014 and 2019. And if you look at the number of patents that get accumulated on many of these products, we're looking at an average 131 patent applications, you know, of which sort of on average 62 are granted. And so when we take all this into account, there's been, you know, particularly cases such as Symposium or the hepatitis C drug, which really, you know, various states were looking at ways to use 1498. They never got used, but the threat of it made other types of arrangements. And I think similarly with PrEP, we've had that discussion. Christopher Morton, who's been sort of involved in this setting up of this symposium, has been, you know, written a lot about it. And particularly when we come to sort of, so that's the 1498 problem. I think it is really, ultimately, I think the how is problematic, because I think as lawyers we'll sit around and happily sort of finesse words and talk about what it could mean. But I think there's a deeper problem. I think the deeper problem is actually, it's a cultural private property issue that the United States has. I think to try and actually litigate these kinds of words in court hugely problematic. And I also come from an international perspective, because when I look at some of the languages or some of the words that are used in compulsory licensing provisions around the world, it's usually, you know, the words reasonable appear in a lot, adequate remuneration appear in a lot of the provisions, but you know, the word entire kind of throws things off here in the 1498 provision. Of course, people have different readings of it, and there is case law that suggests that it's not for profits. But if you're trying to do it for drug pricing, for example, are we going to reward the entire amounts to the pharmaceutical companies? That's one argument that's kind of concerning. And so that's the how problem. I think really, ultimately, I think 1498 needs a revision. We need new language. I think it's actually too confusing. And I think from my experience in the United States, is everything gets litigated when it comes to property, when it comes to patents. So we need language that's actually going to eliminate some of that, make it very clear. And then when we come to the Bayh-Dole provision, again, I think there's far more informed people than I am on Bayh-Dole, but when I look at it in terms of some of the drugs that have come out of public funding, if you take Lyrica, for example, which is a drug by Pfizer, you know, it's developed by Northwestern University, and then you have a company that's making $5 billion a year on a product which has got public funding, and yet the government has no backbone to come in and try and alleviate some of the prices and the pressure. And yet this is public dollars, and we're seeing this with COVID in terms of, you know, should the government come in and act? And so I feel it's all great litigating this stuff, but at the end of the day, you need political will. And we're seeing that around the world in terms of any time any country tries to issue a compulsory license, the United States is first in line to use its power and influence to try and stampede over anybody's sort of sovereignty. So the question of how is actually deeper. I think it's a cultural psyche, and it's actually more than just the legal words that we, you know, you and I can play around with.
All right, well, that's a terrific statement of the case. Mr. Hadad, would you like to give your statement of the case?
Sure, thank you. Good afternoon, everyone. My name is Henry Hadad, and as Artie mentioned at the outset, I'm Chief IP Counsel at Bristol-Myers Squibb. And so today I'm not talking in any official capacity, but rather as an individual that has focused my practice on IP. And let me start by saying I am probably the least credentialed in terms of legal scholarship of anyone on this panel. You know, I'm really privileged to be with this group. However, I hopefully bring some real world experience during my 30 years of practice and my 20 years working in-house in biopharma. And based on this experience, not surprisingly, I do have considerable concerns on the question of whether the US government should utilize compulsory license or Bayh-Dole to appropriate technology. And the reasons aren't, you know, born of concerns about the balance of access. I certainly share everyone's concerns about that. It's largely borne by what it does to the innovation engine. And I'll get into that in a moment. You know, biopharma is the most research intensive industry as measured by R&D spent against revenue. And as Donna mentioned in the prior panel, developing a biopharma product is long, expensive, and risky, taking 10 to 15 years, a huge failure rate, almost 90% of the time, and an average of $2.6 billion per drug. And that $2.6 billion is covering a lot of ground, is covering a lot of failures as well as the few successes. The only legal right that justifies that risk and that expense is an IP system that makes a simple promise to innovators. If you invent something and you work hard and invest to make it a reality, the law will provide a limited period of protection from appropriation, after which that technology is freely available to be used, to be improved. And that's such a fundamental promise that it was part of our Constitution. And, you know, Congress further considered the issue of IP protection in this space in the context of Hatch-Waxman in 1984, which created the generic industry as we know it. And that was really a means to balance innovation and access. And that act has been famously successful. Over 90% of prescribed medicines are generic. And the Hatch-Waxman process is actually a great engine that drives further innovation by branded companies in anticipation of older products going off patent. And in 2010, of course, the BPCIA introduced a biosimilar pathway to create an analogous setup for biopharmaceuticals, biologics, excuse me. So as we've probably talked about in other panels before, the US patent system is in a bit of an inflection point. There's a lot of uncertainty in the patent system, and that is born from a number of different areas. One is a combination of Supreme Court cases that have created so-called flexible standards and maybe eroded some IP doctrines in a way that is either gives less confidence in the promise of that limited period of exclusivity. And at the same time, you know, you have the introduction of the PTAB, which provides multiple administrative challenges against intellectual property. So while other countries, including China, continue to develop their IP system to encourage domestic industry, we seem to be doing a bit of the opposite. So let's add the question of compulsory license into the mix. First off, it's not simply, I don't believe it's permitted under the existing law. I believe 1498 was passed to create government liability with respect to patent infringement on the basis of potentially appropriating patent rights, but not being able to use sovereign immunity to bar liability. So it was not contemplated as a basis for compulsory license as we think about it today. And then turning to Bayh-Dole, while it technically permits margin rights on patents covering government-funded innovations, there are a lot of good reasons why it hasn't been advanced thus far. I think including, and this is just reality, when you consider the investment and the risk that companies have to make, if they have a choice between investing in a technology which doesn't have this potential margin or technology which does, they're going to lean toward investing it where it doesn't, because they don't want to make that investment and then 10 years down the road be told that that investment wasn't warranted because it effectively is going to be taken away from you. Maybe or may not be in terms of reasonable compensation. That's an open question, and I think that's worth discussing. So let me just be clear. I know there are situations where government may have to move forward with respect to patented technology. If a patent holder is not working the patent and an important biopharmaceutical is not available in the event of a global health crisis, I think we certainly have some real live examples there. The US and other countries can and do move forward, and there's existing TRIPS flexibilities just for that reason. But absent that situation, I'm hard pressed to see how compulsory license advances the public good overall, as it would undermine future biopharma innovation. The risk and uncertainty of drug discovery and development requires a stable and predictable period of exclusivity, and every new drug and its success funds a whole generation, a next generation of potential therapies, 90% of which fail. So we've got to make sure that innovation engine is there to improve or save lives around the world. And we've seen this firsthand over the last decade. There have been incredible things that have occurred. Hepatitis C is effectively cured. While we have a long way to go on a permanent cure, HIV is no longer the death sentence it once was. Heart disease has decreased dramatically. Many, if not all, of these products have gone generic. More recently, new cancer treatments like immunotherapy and cell therapy have the potential to extend patient lives and improve them. And every day, new data comes out on these existing products, which further extends these to new patient populations, new type of cancers, and provides hope to them. It's very inspiring to be part of. And of course, the incredible innovations around the mRNA vaccines that led to Moderna's and BioNTech vaccines are just a testament to what a robust biopharma industry can do when pressed with a significant issue. And three things sort of jump out at me just going through that experience. First, companies have partnered with each other and other public stakeholders to find a solution, investing huge sums with uncertain economic outcomes, and largely because it was the right thing to do. And I believe only through the general health of the industry are we able to react in situations like that. Secondly, these companies develop these vaccines with their eyes wide open as to the potential of what they could and could not do economically with them. And I think that says something. I think going into a situation knowing that the government will have a right from the outset may change a bit of the dialogue versus finding out 10 years after you've made those investments. And then last, I would point out, I have not seen really a meaningful instance where the patent system has been an impediment to trying to get therapies on COVID around the world. So, you know, I think it's really a testament to some great work by the industry and frankly by the public sector as well. So let me conclude by acknowledging we have an imperfect system. Discussions like this today and more academic scholarship are an important part of identifying areas to improve and act on them. Constructive and thoughtful discussions balancing the need of innovation and access, really allow our legal system to adapt to the needs today. So I feel extremely privileged to work in this industry. And I really want to thank you all for your time today and look forward to the panel discussion.
All right, Professor Sachs, you're going to take us home for this first part.
Great, so thank you. And I want to join the other panelists in thanking the organizers. This has been a wonderful discussion thus far, and I'm glad to be here. So I'll focus my comments on the point that our existing compulsory licensing authorities are not well suited for our current incentive structures and access problems. And we should think about modernizing these compulsory licensing authorities to do so. I'll say a little bit about both Bayh-Dole and Section 1498 and what they allow you to do, but more importantly, what they don't allow you to do and why that matters to us. So I'll start with Bayh-Dole. I think people have a better sense of this. So Bayh-Dole allows you to use your march-in rights on patents that result from government-funded research. But if the aim is to use these rights for prescription drugs, there are some predictable problems that arise. So first, there's not a one-to-one correspondence between a drug and patents. And because most drugs are protected by several patents, if we're talking about small molecule drugs, we're thinking in the high single digits. But as Tahir's work group has done fantastic work to show, especially around some of these biologics, they may be protected by dozens or even hundreds of patents. And so it may be that some, but not all, of a drug's patents were developed under a funding agreement with the federal government, such that Bayh-Dole limits your ability to use it as a compulsory license for these drugs. That problem is solved in Section 1498, which speaks not in terms of patents, but in terms of inventions described in and covered by patents. So Section 1498 can much more easily be used in the drug context, but it also has gaps that limit its effectiveness. And these apply to Bayh-Dole as well. And so in particular, it doesn't clearly allow you to circumvent either FDA exclusivity periods or trade secrets, which may be of greater importance for particular classes of products. This is not a surprise, given the times in which these statutes were passed and the existing incentives then. And so many people in this conference will be familiar with Amy Kopczynski's article with several of her former students, including Zane, who was on the last panel, which has this detailed history of Section 1498, and it's existed in its current form since, I think, 1942. But we didn't get really the concept of an FDA administered exclusivity period until the early 1980s with the Orphan Drug Act, Hatch-Waxman Act, and then more recently, the BPCIA. So it's not a surprise that Section 1498 doesn't allow you to circumvent those periods, but it is a limitation. And so particularly for complex biologics, which again, just weren't part of the discussion in the 1910s when the first version of Section 1498 was passed, and in the early 40s, the trade secrecy issue is likely to be particularly problematic. And so when you take these limitations, in its current form, Section 1498 might be most useful when dealing with drugs of more moderate ages. So drugs whose exclusivity periods have expired, but whose patents are still in force, where their manufacturing techniques are either known or can be reverse engineered. This is more likely to be true for small molecule drugs or simpler biologics. And one set of products which is starting to fit this category is the hepatitis C drugs, which were approved mostly in 2013, 2014. Some of them have follow-on approvals that may make this more complicated, but their initial FDA exclusivity periods have likely lapsed. I think these limitations are important ones to remember for people who are on both sides of the issue. And so one argument you may hear from the pharmaceutical industry is that using these laws would destroy the incentive to innovate for prescription drugs. And I do have concern about this. I come out somewhere in between Henry and Tahir on this issue. I think the answer is sometimes for when you should use these. But in this context, because you can't use Section 1498 before the FDA exclusivity periods have lapsed, the argument can't just be it will destroy innovation. The argument has to be that 5 or 7 or 12 years of exclusivity isn't enough, which is a harder one to make, I think. And then on the other side, I think when we're talking about how and when we'd like to use these compulsory licensing authorities, we should think more about whether there are existing ways to circumvent FDA exclusivity periods or trade secrecy protections. I've thought more about the FDA side of this, but I bet Artie has thought more about the trade secrecy side. And if not, can we create ways through either legislation or regulation? Thank you.
Terrific. Well, those were all great statements of the case, and we've got a range of positions, I think it's fair to say, on all of these issues. Before I get to all of my questions, though, I would like to see if any of the panelists have an interest in responding to one another in some way, because you've all been provocative in good ways, and it would be good to see if you wanted to respond to any of you, and you should just unmute yourself, obviously.
I would.
I agree.
Oh, I'm sorry. Go ahead, Rebecca.
That's all right.
I will call.
Yeah.
Becky.
Professor, I agree with much of what everyone has said, and I think that these are all reasons why. Well, one thing that I do disagree with is I don't think it's true that everything gets litigated in the U.S. I think much gets negotiated in the U.S. And you just don't see those things. We may be litigating more things than get litigated elsewhere, but we are also working a lot of things out through voluntary or consensual agreements. And I think a lot of these rights sort of set the stage for who has a seat at the table and who is participating and what are the relative positions of all of the parties. One reason maybe why you don't see more compulsory licensing happening in the US is that everybody's bringing something else to the table, and you can't simply go it alone and litigate the issue and expect to accomplish anything, partly for the reasons that Professor Sachs has been explaining. There's too many different sticks in the bundle of rights that are held by different parties. And so a Bayh-Dole patent is likely to be one patent. By the time a new pharmaceutical product comes to market, there's a host of patents and lots of know-how and supply chains and production facilities and lots of reasons why you're not seeing, even though all sorts of countries in the lead up to or in the early days of the pandemic were making noises about compulsory licensing. You're not seeing that happening here because they can't simply go it alone. They need to work with the suppliers of these vaccines in order to get access to them. And so they work out a deal. Israel worked out a deal with Pfizer, even though they have a very favorable compulsory licensing laws, and they worked out a deal that involved paying money and also providing data to Pfizer. And it's quite valuable all around. So everybody has something to bargain with, and the potential for compulsory licensing doesn't necessarily mean that that's the way it's going to go.
All right. Does anyone want to respond? Tahir, of course, you were up.
Yeah, sorry, I jumped in early. No, I was probably a little generous by saying everyone. It feels like that every time a patent comes in, there's always some action about something related to the Constitution and property. But anyway, the couple of things just what Henry said. This sort of social contract of a limited period of protection. I think we're living in a world now where that is kind of not quite what it was intended to be as it was written in the Constitution. We've seen the growing number of years. I mean, on average, the top 10 selling drugs have at least, by their patent portfolios, whether they will actually use them all is at least on average 38 years. So I don't think that's entirely true in the world we live in today. And then, on the TRIPS flexibilities and, also to Rebecca's point, I think we have a history where people, and again, this is not per se to this conversation, but I think it's the cultural underpinnings of it, is anytime anybody's tried to use them, let's just put COVID aside and all the peculiarities of who needs to work with who, there's an immense amount of pressure to actually use the compulsory licensing provisions, even if countries have reasonable provisions and are very clear how when they can use them. So I do think that it's not as straightforward, because the how is the problem. And I think it comes from not just nice legal language, it comes from an implementation and how governments are allowed to act in this current political economy. And I think the US as a driver of the IP system as it is today, I mean, obviously China's got its own version now, but I think China's just following what the US is doing. And then eventually in 20 years, if China is a holder of all the biotechnology power, what will the US be doing when it comes to actually demanding some kind of compulsory license because it doesn't have certain technologies? So I think we need to maybe sort of see past the end of our own noses here a bit and sort of look at where we're going with a lot of this sort of proliferation of IP.
Henry, we've gone to first names now since we're all familiar.
Yeah, absolutely. Absolutely. I really enjoyed the comments of everybody and, you know, just responding to what Tahir just said. You know, I realize he's done a lot of good academic scholarship on patents and the number of patents per product, but I think at times when you look at the reality, first off, in the average exclusivity for a biopharmaceutical is, I think, 12 to 13 years, and that's been done when reviewed by certain independent groups. And then if you look at the Orange Book, which lists small molecule patents and what's actually litigated, what the end result is, the net number of patents, single digits, low single digits max. We don't seem to question whether an iPhone may have multiple innovations, but we do seem to question whether a biopharmaceutical does. And I can tell you that over those 15 years, and it's particularly true in the biologic space, admittedly, you know, it's so much complexity to first identifying the active, but then making it and then using it and then new potential indications for it, extending it from people who have melanoma to people who have lung cancer. And I realize that creates a little complexity here, and there's no doubt. But I think these are the kind of innovations we want to incentivize as a society. We want to encourage more opportunities for patients to improve their situation. So, you know, from my perspective, I think the IP system does what it's supposed to do. And we have to remember that even where there are multiple patents on a product, overwhelmingly, the original product proposition goes off patent. And there may be other indications or a new version of it that may stay on patent, but the old version does go off patent. And again, that's something we want to encourage going forward as a society. And I certainly, as a citizen of the US or of the West, do not want to cede biopharma innovation to other countries. I realize the US and Western Europe to some degree, maybe some other countries have shouldered the burden of innovation and the expense of innovation, frankly. And to the earlier panel, you know, someone mentioned earlier whether it's a bit like defense. I don't know whether it is or not, but I do think it's something we as a society should have an open discussion about. How much of that burden of innovation should we shoulder versus the rest of the world? I'll stop there. And actually, one additional point to Rachel's points, because she has some excellent points as well, which is on the data protection. The small molecule data protection, which was part of the original Hatch-Waxman Act, is 5 years. And it's actually 4 years to a patent challenge. And I can tell you from personal experience, that is not a sufficient runway to develop a small molecule product in of itself. And the patent system is particularly important for those situations. So I would love to see a situation where there was more data protection for small molecules that would run concurrently to patents, so it wouldn't extend the time, but it would provide predictability and the opportunity to take some older drugs, which maybe never were developed but are off patent, and bring them to patients. So I think that would be a great thing as well. And I'll stop there. Thank you.
Rachel.
So I want to make a small point, which I think is floating around and related to some of the points that several of us have made. The title of this panel is Whether and How the US Government Should Exercise Its Compulsory Licensing Authority, but we haven't really talked about what to exercise means. And we've been thinking about it we've been talking a little bit about it in the sense of what if the government were to formally invoke and carry to its full conclusion the Section 1498 process, what would that look like and what would it require? And it has all of the pros and cons that we've been talking about, but to exercise the authority may mean to credibly threaten to use that authority in the hopes of obtaining a much better deal from the company involved. Mm-hmm. Recognizing that all parties know that it's far easier to do that and more profitable for the originator company than to force everyone to go through this process. And so you could tell me that you could make a convincing argument, I think, that the Louisiana and Washington uses of the subscription model for the hepatitis C treatments was an exercise of compulsory licensing authority, given the extensive public discussion of the use of Section 1498 that preceded those licenses. Now, Do I believe that Secretary Azar was on the verge of issuing a Section 1498 notice to the companies about their drugs? No, I do not. However, I do think the sort of building pressure and statements and interest in this issue were relevant to that process. So I think that's something worth bringing in, you know, if people in the Q&A are interested in talking about that as well.
So I'm so glad you brought that up, because I do think that's precisely part of the puzzle, and maybe part of the reason why NIST has felt compelled to clarify that pricing isn't part of the equation even under Bayh-Dole. Because in point of fact, the prior administration, we'll see what happens with this administration, seemed to, in the context of Sovaldi and some other situations, be not averse to threatening, and threatening may be all that's necessary in a lot of cases. So this is sort of an open question to all, but maybe mostly to Henry, and I don't mean to pick on you, Henry, but it is the case that these threats are out there and they play a role. So, you know, aren't we already here in some respect?
Yeah, you know, Artie, I think it's really a question of, is it reasonable to expect private industry to bear the burden of healthcare where countries are not willing to necessarily pick up the bill? And I think there's a fair amount of that already goes on. I think when you look at how Hatch-Waxman and the BPCA basically permits the use of the data, so there's no need to spend $1 billion to make a generic or a biosimilar. You can go in and with limited data get approval because you're utilizing data. In a way, that's leveraging and that's co-opting the investment of a company that's done the work. And it makes sense, right? It makes sense from a policy. It would be crazy to reinvent the wheel, so to speak. But I don't, just because it gets done doesn't mean it's necessarily right, in my view. And I think the broader question should be, well, is there some way to look at how we provide healthcare across the boards? And it's not just biopharma, right? It's hospitals, it's the middlemen, it's the PBMs, it's the whole enchilada, and provide reasonable and ethical coverage for people across the boards, rather than sort of saying, this drug's too expensive, I'm going to threaten this unless you do what I say.
So yeah, that's a really important point, that this is, and as the first panel noted, pharmaceutical spending is a small part. I would say probably more like 16 or 17% than 12%, but a small part of the overall healthcare dollar. And maybe we should be spending more. And that leads to a question that's also in the chat, since Professor Willett is in the chat and is listening closely, clearly, which is, at the end of the day, let's say we went past whether and went to how. Let's just say, for the purposes of argument, would we want to go to some sort of system where we compensated for, where reasonable entire compensation, to go to Tahir's point, was all of the social welfare value provided by the drug? For example, that was one possibility raised by the first panel. Or would it be some sort of cost plus arrangement? I mean, it's not necessarily the case that, as Professor Willett put it, because she went to Yale Law School, that a liability rule has to treat industry less well than a property rule. So translate, we could pay a ton of money in reasonable entire compensation. We could pay the entire social welfare benefit provided by Sovaldi, which would probably be in the billions, I would guess, easily, right? Would that be okay?
Well, so Lisa and I write together. We've been writing a series of posts with our colleagues, Nicholson Price and Jake Shirko, about innovation in COVID-19 on Lisa's blog, writtendescription.blogspot.com. So Lisa knows, or I hope knows, that this is something that I've now internalized by writing with her for so long. So I will say that I agree. And one reason that I was particularly nervous about the use of Section 1498 for Sovaldi when it was first created was, I thought this is precisely the type of drug that we should be paying pharmaceutical companies a lot of money for. This is a drug that cures a disease which is predominant among disadvantaged populations, and there are huge social welfare advantages to being able to eradicate a communicable disease that's so rare. However, it was such a budget buster for states. So some people at the time proposed that the government should buy Gilead and make the drug available at cost. It's not at all a crazy proposition. And so this idea that Gilead should be paid a lot of money for doing what it did, but also that we can and should think about using compulsory licensing, you can hold both of those views at the same time. I really worry about this idea that we would disproportionately disadvantage innovation into neglected diseases by only using Section 1498 in those contexts. But my bias is, like Daniel's, that we should pay more for drugs that work better. And I will say, I think I should just disclose that I'm on one of ICER's public advisory committees. I'm not an employee, I'm an independent. I sit on one of their public panels, and you should all come to the meetings. But so my biases are in line with the work that was talked about on panel 1.
Henry.
Yeah, just further building on what Rachel said, one of the challenges in quantifying what reasonable compensation looks like is that rarely will you say, well, you spent $2 billion on this particular drug, and I guess you get some type of kicker because you're providing some social benefit. It's the way the system is built is that today's revenue funds tomorrow's therapies. And you can't just look at that one drug in a vacuum and say, that's the thing, because you got to look at the other 90% of the drugs that was in your pipeline that didn't make it, that you spent a ton of money on over the years. And if you don't have that sort of return, the next generation of therapies just doesn't happen. And I'm not saying this because I think there's a lot of valid points being raised, and access is a serious thing. And I know companies take it seriously, patient assistant, governments take it seriously, people take it very seriously, of course. I'm a patient. My parents, my mom's a patient, my family is. But at the same time, I do worry about chilling the innovations that are coming down the line.
Henry, let me do a quick follow-up. So let's say we agree with Henry Grabowski, my colleague here at Duke, that including the cost of failures, including everything, a drug costs, and including the cost of capital at a significant percentage, so 13, 14%, a drug costs $2.5 billion to develop. Add a profit kicker to that, and are we done?
Yeah, I listen, Artie, I don't think so necessarily. I mean, I think there's a model there. I mean, you certainly, we've talked about, I mean, I'm a firm believer in the IP system. I think it's been the engine that has driven us to the greatest innovations the world has ever seen. And I think that's great. But, we've talked about people saying, well, why don't we just give money out? So there's no reason they're mutually exclusive. If the government has something they've developed and they want to say to a company, we'll give you this amount of money, a flat fee up front, knock yourselves out, and this is appropriate incentive, then great, let's see if it works. What I fear is not, it's going into these things eyes wide open, which is where it works. What happens is if 10 years later, somebody says, oh, and by the way, we're taking this from you, that's where it breaks down and suddenly investors flee. They go to safe investments, which are commodities, and they don't go to the high risk R&D intensive ones because of that fear.
So now you've got lots of hands. So I think Becky was first and then Tahir.
Yeah, I mean, IP is a very high risk reward, always has been. There's a lot of invalidations of patents, always has been. There's advantages to taking a risky strategy on the reward side, but sometimes you're lamenting that we need security. We need to be sure that at the end of the day, we're not going to have these profits pulled away from us. And sometimes you're saying that you want the possibility of extraordinary returns. I mean, I can see benefits to both of those systems, but you really can't have it both ways. the closest thing I think to a sure bet is regulatory exclusivity, and that it's very hard to invalidate. I think that the pharmaceutical industry initially was sort of not pushing as hard on that as maybe on patent protection, as you know, believing that that was the side their bread was buttered on. But you know, you can't have it both ways.
Yeah, maybe a quick response to Becky, and then I know Tahir has a comment too. I would just say on regulatory exclusivity, well, I mean, clearly that was the focus in the BPCIA, because there was a recognition that biologics patents maybe just aren't quite as robust as small molecules. But I would say that there have been various things talked about, like modern cures, for example, where at the outset you say you have a choice when it comes to biosimilars or small molecule generics. You can today, when you get approved, choose to get 15 years of protection or choose to rely on the patent system. And I would say that degree of predictability has some advantages. The one downside of it is it, you know, depending on the waxing and waning of society and people's concerns about pricing today, they could knock that down significantly in a way that there's no recovering from. So I think there's a bit of a balancing act, but I like the idea of data protection. It does provide predictability, Becky.
So Tahir.
Yeah, I seem like the outlier here. But I think, first of all, you know, when we talk about compensation value, what's interesting to me is if we look at the rising prices of drugs, and these prices are set by the industry, and we don't have any kind of, like a lot of the European authorities that actually at least put some value pricing qualities on the prices of drugs. And so if we're going to be doing compulsory licenses, if you know the how, then we do need an independent, I mean, courts can do one thing, but we do need some kind of medical valuation of these drugs and what they really do in terms of value if we're going to do these kinds of assessments. But I think it's okay for the industry to say, you know, talk about innovation and what have you, and what the value should be. They're the ones who are driving up the value according to what their shareholders and their investors want. And I think that's not what a health system should be entirely built upon. And I also just wanted to go back to something that Henry mentioned, and you mentioned Grabowski's name, so it came to mind. You know, the work that's being done in terms of the average life of exclusivity is only for small molecules. We're living in an age of biologics now, and if you look at the biologics on average, according to our data, we're looking at 17 to 20 years of exclusivity on the market before any competitor can even get a sniff. And this is the way it's headed. So I think, you know, the Grabowski thing gets wielded out every time. And I've never yet seen anyone come up with a biologic sort of statistic. And so I'm telling you, based on the data that's out there, and I still yet have had to hear from Bio, despite being on the same panel as Bio, and they always go to the Grabowski statistic. So it's apples and oranges. So we're living in a different world now. And I think, you know, old statistics are not relevant.
Just a quick response to Tahir,
Yeah.
Which I would just say that with respect to that here, yeah, I agree that things haven't, the dust hasn't settled on the BPCIA yet, right? I mean, it's relatively recent. It just has basically been implemented. And there were a number of products that were pre-BPCIA that ended up becoming part of the BPCIA. I think over time, as the dust settles, you're going to see a little bit more predictability around the time. I think it varies greatly at this point now.
Rachel.
So this is why in my introductory remarks, I took pains to note that exclusivity periods are just not part of what 1498 allows you to get at, because I find it really challenging to continue to confront the innovation arguments when they can't be used until 5, 7, or 12 years after a drug is brought to market. And so, Henry, I really appreciate you saying that 5 years is just not enough for exclusivity periods. I find that to be helpful in terms of thinking about what's going on. But, you know, you mentioned 12 years is roughly an average period, although we've just talked about how that's for small molecule drugs rather than for biologics. You know, you mentioned modern cures, but one thing you didn't mention is that modern cures would have given for most drugs a 15-year exclusivity period. And so that would have dramatically elevated from 5, 7, or even 12, much longer exclusivity periods. And so a question is, what level of exclusivity, or what period of exclusivity, right, would companies accept in exchange for price regulation thereafter in whatever form that we decide we would like that to be? And there is no answer that I've ever been given, right? I imagine it's very different for different types of products as well. But I think it's helpful, I think, to clarify some of these distinctions and points of debate, because if it is your position that 12 years is enough, then compulsory licensing of biologics shouldn't be troublesome to you, because you should be able to get that 12 years and only then have Section 1498 be used.
Yeah, Rachel, so just to respond to that, I was citing certain studies which I think they range from 12 to 14 years depending. Of course, patent term restoration is capped at 14 years in the US, it's 15 years in Europe. So, I mean, there is a variety of views. I think you're right. I think it's very product specific, but I do think businesses thrive on predictability. I mean, it can't be a predictable 1 year period, of course. It can't, and I've mentioned to you 5 years isn't enough, but I think having a predictable period somewhere in the range that some of these parameters have set out, whether it's 13, 14, 15 years. The modern cures, I think, said 15 years. I think that provides a predictability and a runway which justifies investment. I don't believe that compulsory licensing is a wise decision north of that. I think, first off, if you chose modern cures, you're actually asserting your patents against biosimilars and small molecules. So that effectively ends that. And remember, for every biologic in particular, there are many, many branded competitors. And that's one of the more interesting things and dynamic of the biologic space, is that for every target, there are several competitors, and they may end up having patents which cover each other, but they more often than not end up licensing each other because they believe it's in the best interest of patients and themselves to be on the market and competing in the marketplace.
So I think there's a CLE announcement coming up, and then after that, I have a question that relates to what Henry just said.
Yeah, thank you so much. So it's me again, your friendly neighbor CLE provider. I will be sharing the code momentarily for panel 3, and perhaps fittingly, it is HATCH, H-A-T-C-H, you know, either the object or the senator. So panel 3 CLE code is HATCH, H-H. Again, if you are just joining us, you can find the attestation form either in your email from Michael Weinberg, or you can go on the events Eventbrite page where you can find it in the download link. We will again be sending a Google form shortly after the close of the symposium. You can upload it there. Please register to the Eventbrite to make sure you get that email. So yeah, the code once again for panel 3 is H-A-T-C-H, HATCH. If there are any questions about CLEs, you can email me at kq364@nyu.edu. Once again, HATCH, H-A-T-C-H, CLE code for panel 3, and back to you guys. Thank you.
So the question I had is, let's say, for at least for the purposes of argument, that we figured small molecules out, that Hatch-Waxman did an okay job. We've got 12 to 13 years effectively, despite the uncertainty. You know, it's done an okay job on biologics. We've seen that prices really only go down for biologics, and to the extent they do, when biosimilars enter, and that's been largely the case for small molecules historically anyway. So one question is, what can we do, if anything, to deal with the trade secret in manufacturing problems such that biologics and biosimilar manufacturers, not just branded biologics, can enter? And Rachel, I'm going to turn to you on that one.
So there are stick options, there are carrot options, but there are also other options that bypass the question entirely and regulate the prices of the products. And you can do that using compulsory licensing, but which has limitations for the reasons we've been talking about. And so, you know, most governments simply choose to set the price at which they will reimburse the products. And so at that point, it may matter less whether the product continues to retain exclusivity or not, because most of these companies are willing to provide significant discounts off of the US price for their products. And so I think you are seeing increasingly in the US a willingness to say, why is it that we pay so much more for the very same products? And price regulation is a big part of that.
All right, well, we have 3 minutes left, and so I'd like to give each of you an opportunity to make a 1-minute closing statement, which obviously gives us 4 minutes, but we can run 1 minute over, I think. So let's start in reverse order. Rachel, you go first. And maybe you can, I don't know if you want to waive it, given that you just spoke.
Sure, I'd love to go last.
Okay. All right, let's have Tahir go.
All right. I think just in a nutshell, we live in a system whereby if the pharmaceutical industry is, if you any moment you mention compulsory license or any kind of other removal of an exclusivity, they say, well, there's not going to be no innovation. They throw their toys out of the pram, and basically there's a threat. And I think that in itself is a fundamental problem to the kind of system we live. If we're living under threats where the power holders can broker the rights that they want and get, and compulsory licensing really is the only counterbalance to that, and yet we're not willing to use it, then I think we really have to look at ourselves as a society and say, you know, are we living under a society where basically those who have the power can just threaten and get their way? And I think we really have to look at the tools at our disposal and start to use them to create a little bit more of an equitable healthcare or an equitable drug pricing system.
All right, Becky, I'd like you to go second. You're muted, Becky.
You know, I think that the political economy in this area is in flux, and we may see some profound changes in the years ahead. There's been a lot of shifts. I think, you know, in this particular moment, the pharmaceutical industry is looking really good because of their extraordinary success with these COVID vaccines. At least vaccines. I think they're looking better than they've looked in a long time. Although they've been less successful with the therapeutics. The government is also looking pretty good right now. I was interested to hear Daniel Hemmel observe earlier that this is socialized medicine looks great. I mean, you know, we're getting all these vaccines right now under a single payer system, after all. You know, I think that there is a lot of anxiety about access to healthcare in the U.S. More than there has been, certainly more than there was at the time of the Bayh-Dole Act. I think it may be that there is going to be more forces to make profound changes in the healthcare system than there would be to change the Bayh-Dole Act, paradoxically, do something more modest. You know, the universities have sort of changed their tune on the Bayh-Dole Act. They've become much more unabashed about asserting their own rights in their own interests in their own patents as a revenue source. At the time of the Bayh-Dole Act, they were much more coy about that. So they're so over that now. But you know, the politics of this are really hard to sort out and to figure out where we're going to land. But I'm sure that things are going to change going forward. For now, I think there's worse things to be had than ambiguous legal rules that give everybody, you know, give everybody something to argue with and come to the table with and try to achieve good results, as we're achieving, I think, with these COVID vaccines. It could be better for sure, but it couldn't be much better. And this is much better than I think we had any reason to hope for at this stage.
Well, I wish I had you go last, Becky, so we could end on that high note, but I think Henry and Rachel are the order we will follow.
Tough act to follow. So further to what Becky said, I do think that COVID does sort of provide a nice example of what can be done when the private sector and the public sector work together, but they're coming in with their eyes wide open at the outset. Again, not something that's going to be appropriated 10, 15 years after you've made a huge investment, but at the outset, people realize what the opportunities are and what the investments need to be. And so, that is, I think, the framework we need to really think about. If the government sponsors research and they do a deal with a small company, they should say, and we reserve the right, we're going to come in and take this one day. And then a bigger company who wants to do a deal would know outright, is this a company I should do a deal with, or is it one I shouldn't? That probably wouldn't work for the reasons I mentioned in the outset, which was you're going to be very concerned about that if you're going to have to invest a couple of $1 billion in a drug. But I do like the COVID example, to Becky's point, because of that example of the early appreciation of the circumstances around the relationship. And, in terms of threats, that Tahir mentioned, I think that the threat isn't that innovation will go away. I think that's a foregone conclusion. I think not it will go away completely, but, every time you undermine the incentives for innovation, it's going to be reduced. I mean, that's just a natural human inclination. How much? I don't know. It really depends on the situation. So I think the threat of compulsory license is what raises that concern, and something we have to watch as we think about this going forward. But I just want to thank everyone. I thought this was a great panel and really appreciate everyone's comments.
Thank you. And Rachel, you're going to close it off before I give my closing remarks.
Thank you. I apologize for punting. I'm used to being at the end of the alphabet and was not ready to go first. So by discussing, the topic of today's panel, compulsory licensing, it seems narrow, but I think we've also been provided some lessons into seeing how the different parts of our innovation ecosystem work together or don't work together. So it's not just about patents, it's not just about exclusivity periods, government reimbursement in the form of royalties, trade secrets in the manufacturing space, etc. We see all of the arguments from these arguments about innovation. I'm particularly concerned about the one-way ratchet that we can never reduce prices or we will be harming innovation. There's never any sort of agreement about what would be permitted. And we've been seeing that once again in this space. And then to close, I'll just say that many drugs have high prices, but they have high prices for very different reasons, especially as we've talked about with small molecule drugs and biologics. And compulsory licensing might be a solution to some of these high prices, but it can't structurally or practically be a solution to them all. So this conversation should be understood as part of a broader access to medicines, but also innovation protecting reform effort, which I think is important.
Well, thank you to all of you. I totally agree with what was just said, that this might have seemed a narrow topic, but we have expanded it to encompass so much about our healthcare ecosystem, not just our biopharmaceutical ecosystem, but our healthcare ecosystem and all the complexity and problems that it has. So I wish we could say we fixed it all, but that's why we have day jobs. All right. Thank you to all of you.
Thank you.
Thank you, Professor Rye.
Thanks for chatting.
I will say I'm not surprised that this went over time. I knew this is such a contested topic usually, and I just want to commend every single person on this panel for how professional they handled it. At the end of the day, I think we're seeing a common theme amongst all these panels, and these are value judgments. This strikes at the heart of morality at the end of the day. And although we may have differences in how to get to the ultimate result, I think we all can agree that we want better access. Thank you all so much. We're going to have a shorter break, everyone, but the last panel is going to be a wonderful one, so stay tuned.